Okay, welcome to the Personnel Data webinar with the Data Practices Office. Thank you for joining us. The Data Practices Office is a small office in the Department of Administration. We are a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions about those laws from members of the public and government. If you have questions about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We also record our webinars and post them on the Data Practices Office YouTube page. So if you missed part of today's webinar or want to go back and watch it again or find one of our previous webinars, you can do so on our YouTube page. If you'd like to download a copy of the PowerPoint right now, I'm going to share the file for you to download and save to your computer. So give me just one moment, please. Okay, a pop-up window should be appearing for you to download the file. If it doesn't work for you, and I know that it doesn't always work for everybody, you can visit the webinar webpage on our site where you registered and scroll to the bottom to find this presentation. I think you can find the slides under the personnel webinar tab that you can open up, and the file should be there for you. So again, if you aren't able to download a copy of the file today, it is available on our website where you registered for this webinar. Okay, so here's the schedule for today's webinar. As noted, we will leave some time for a Q&A session at the end of the webinar. So please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send in your questions so we can all be sure to see them. We don't want to miss one of your questions. You can start sending your questions now, or you can wait until the end of the presentation. So today's webinar is the first of 4 webinars focused on personnel data that the Data Practices Office will be presenting over the next several weeks. If you've been doing this work long enough, you'll probably remember when our office hosted some similar webinars in early 2020, and these webinars will help highlight several of the updates and changes that have been made to Section 13.43 over the past 5 years. Today, we'll focus on the definition and application of personnel data under Section 13.43. We'll talk about which elements of data about government employees are public and briefly highlight how elected officials' data are treated by the Data Practices Act. In future webinars, we'll discuss sharing personnel data as well as discipline and complaint data. So if you have questions on those topics, we'll ask you to wait until those webinars in a couple of weeks to ask the questions. If you send us those questions on those topics today, we will probably hold off on answering them, but we may try to incorporate them into another webinar in this series. If you have a question that can't wait, please feel free to call or email us, and we'd be happy to offer you some more specific guidance. Before diving right into Section 13.43, I do just want to offer a quick reminder on the basics of the Data Practices Act. As I'm sure you all know, Chapter 13 of Minnesota statutes is the Minnesota Government Data Practices Act. It applies to government entities and private entities under contract to perform government functions. It presumes government data are public. It classifies some data as not public, as do other statutes. It provides different rights for members of the public and data subjects, and requires that data about people are accurate, current, complete, and secure. The administrative rules implementing the Data Practices Act are found in Minnesota Rules, Chapter 1205. The rules specifically apply to data on individuals, so data about people, and contain helpful guidance, particularly in the area of personnel data, which is all data on individuals. I should note that we are currently updating these rules, and you can find more information about that process by going to our website and clicking the rulemaking link on the blue bar that runs across the top of the page. Okay, let's now turn to personnel data specifically. Section 13.43 of Minnesota statutes defines and classifies personnel data. We'll take a look at each part of this definition. The first aspect of this definition is government data. Remember, government data is defined by the Data Practices Act as any information that's recorded in a tangible form, regardless of any format or where those data are stored. If the information about an employee is not government data, then that information cannot be personnel data. For example, an email that a city administrator receives commending the impressive work of the city's Parks and Rec director would be government data because it's information in a tangible format. However, if someone calls the city administrator to praise the Parks and Rec director, that conversation would not likely be recorded and would not be government data. In short, information must first be government data in order for it to be personnel data. Second, the data needs to be data on individuals. Individual is defined as a natural person, which is a living human being. It does not include companies or other non-human beings. An individual does include the parents of a minor or the guardian of an incapacitated person. So those individuals, parents and guardians, can exercise the rights of their dependents. Data on individuals is defined as data in which any individual is or can be identified as the subject of that data, unless the appearance of the name or other identifying data can be clearly demonstrated to be only incidental to the data, and the data are not accessed by the name or other identifying data about an individual. Minnesota Rules 1205.0200 subpart 4 also says that if data can be used in connection with other data elements to uniquely identify an individual, the data would be data on individuals. So, in order to be personnel data, the information has to be government data about a living human being, and that human being must be the identifiable data, subject of the data. So you cannot have personnel data about a company, for example. The definition then includes current and former employees, applicants, volunteers, and independent contractors who are individuals. So, contractors who are individuals are also subject to the disclosures and protections of Section 13.43. Generally, employees of contractors that are companies are not covered in the same way regular government employees or independent contractors are. If you have a question about contractors, employees, please give us a call and we can talk about it. Remember that the Data Practices Act does not apply to the judicial or legislative branches, so access to information about employees of the courts and the legislature are governed by provisions outside of Chapter 13. So we just walked through the definition of personnel data and what is included, but not everything an employee creates is personnel data. As we discussed, Section 13.43 applies only when an employee is the identifiable subject of the data, meaning that the data are about that employee. If an employee writes a budget report as part of her job duties, that report is not necessarily about that employee. We receive and send a lot of emails at the Data Practices Office, and those emails contain our names. But those emails are generally about data practices or the open meeting law and not about us as employees. As a result, these emails would not be considered personnel data under Section 13.43 because they are part of our official duties in providing technical assistance. In short, if data are generated by or related to any person who might fulfill a specific job role, then those data are not likely personnel data. Rather, personnel data are unique to a specific individual. Additionally, the commissioner issued an advisory opinion in 2001 where a city asked about the classification of certain data an employee created that was about the employee but related to personal matters. The city had a policy that allowed employees to use work resources for limited personal use. The commissioner concluded that the information was not government data at all, and the information was outside of Chapter 13. Therefore, the data at issue, in that opinion, were not personnel data, but rather personal data. Another example would be if an entity has an incidental use policy and an employee sent a happy birthday email to their mom from their work email. That would be personal data and outside of the Data Practices Act. But if an employee emails her boss about a doctor appointment, that would fall under personnel data because the government entity is collecting that data about the employee, and the data are related to the fact that she is an employee. In either case, the data in those emails are likely not going to be available to the public. So the practical outcome here would be the same. Consider whether your entity has this type of incidental use policy and how it might affect the classification of similar types of data at your entity. Now let's talk about the classification of personnel data. Section 13.43, subdivision 2, lists public personnel data, and we will go through some of that list in a moment. Subdivision 3 lists public data about applicants, and Subdivision 4 says that all other personnel data are private. Therefore, the public presumption in Chapter 13 that I mentioned in an earlier slide is reversed with respect to personnel data. That is, all personnel data are private unless there is a provision that designates the data as public. What data elements are public? Subdivision 2 classifies the public elements for government employees, volunteers, and independent contractors, and they are listed on the next 4 slides. I'm not going to read all of these out to you, but I will point out some of them. So, public data includes the names of employees, the actual gross salaries of those employees, as well as the value and nature of the various fringe benefits they receive as public employees. Terms and conditions of employment relationship. If you are an employee with a contract or have an employee with a contract, that contract is generally going to be public as terms and conditions of employment. The DPA generally classifies elements and not full documents, so there is a chance that there could be some private data in an employment contract, but it's likely that would be fairly limited. More public elements. Note here that the bargaining unit is public, so if an employee is subject to a collective bargaining agreement, that is public data. However, whether employees are dues-paying members or non-paying members of their respective union is not listed in Subdivision 2, and that would be private personnel data. The first and last dates of employment are public. The reasons for last dates of employment are likely private data, but in some situations, those data may be public. If someone has resigned or retired, not in the context of discipline, then those reasons are private data because they are not listed in Subdivision 2 as public. But once an employee has had their last day, that last day of employment would be public data. If someone is terminated for disciplinary reasons, then the reason the individual is no longer employed would be public under other language here in Subdivision 2. Again, we'll talk about discipline in the future, but there are some public elements related to complaints that might make more data about employee separations public. Settlement agreements are public, and these agreements need to include specific reasons for the agreement when the employee is getting more than $10,000 of public money. We don't have additional guidance on what specific reasons means, but presumably it is something more detailed than what would be provided in an agreement for less than $10,000. I think that the intent behind that language is that the public gets to understand why significant expenditures are necessary or warranted in certain circumstances where a government entity decides to settle an employment dispute with an employee. Payroll timesheets or other comparable data that are only used to account for employees' work time are public. This language means that the public can see whether an employee used 10 days of vacation in the last month, whether they took sick time, whether there are days for which an employee is not getting paid, etc. The limitation in this element is that the reasons for sick time or other types of medical leave are private data. Government employers use a variety of timekeeping systems and software, and at times, and at some entities, there may be very specific codes on a timesheet that might reveal reasons for the use of sick time. For example, the state has a specific leave code for bone marrow donors. So obviously that code would disclose a reason for medical leave and would be private data. Other employers have very broad codes that might not reveal any private data. So requesters might receive different types and amounts of data based on how each entity administers its payroll. So as you can see from these 4 slides, there are many types of public data about public employees, volunteers, and independent contractors. In addition to these elements, there are also public data on applicants, which we'll discuss after we highlight some of the advisory opinions addressing Section 13.43, Subdivision 2. So I'm just noting a few advisory opinions for your reference. The Commissioner has issued many advisory opinions on personnel data, and these are just some of the highlights. There's an older opinion from 1997 that says that email addresses were not contemplated at the time Section 13.43 was drafted, but Subdivision 2 does not say U.S. postal address either. Rather, the language of Subdivision 2 states that work locations are public data, and the Commissioner opined that email addresses are part of employees' work location because it is a method to communicate with government. This opinion was more of a nod to practicality and policy, just based on more modern working habits, even though that one was from more than 25 years ago now. The value and nature of employer paid fringe benefits are public, and Advisory Opinion 04-017 says that the dollar value of an employee's health insurance benefit is public. So even if that might reveal that the employee is taking dependent coverage or single coverage, those costs that the employer is paying are public data. The opinion from 2008 was about Tubby Smith, a former basketball coach at the University of Minnesota. The Minnesota Daily, which is the U's student newspaper, asked for access to a form he was required to submit about outside compensation. The commissioner concluded that the form included data that were not added remuneration because ultimately it was unrelated to Coach Smith's job duties at the U. Therefore, the form was private personnel data and not public under Subdivision 2. Advisory Opinion 13-002 says that requesters are entitled to see data elements in the documents where they exist. For context, some entities will respond to requests for personnel data by creating a list of the public elements. Remember that government entities do not have to create data in response to a request. So, if a government entity chooses to create a list from an application or resume, some requesters might be okay with that. Others may want to see the data in a redacted document, and this opinion from 2013 says that they are entitled to see that. Finally, Advisory Opinion 21-005 discusses optional work-sponsored trainings that an entity offered to its employees. The employees were paid to attend the training or could receive other benefits such as continuing education credits and graduate credits for a salary lane change. The commissioner determined that employees' participation in these trainings fell under the public category of work-related continuing education. As we discussed in the definition slides, Section 13.43 also applies to applicants for employment. Subdivision 3 lists the public elements about applicants. Note that names are not public when an individual applies to work at a government entity. Names become public if the applicant is selected as a finalist to be interviewed by the appointing authority. An applicant's rank on an eligible list applies to those positions and entities that use a civil service model for hiring. And we often get questions about whether resumes are public. Since job history and education and training are public, there are likely going to be some public elements on a resume. Ultimately, the content will determine which elements on a resume are public and who can get access. There are several advisory opinions that discuss Section 13.43, Subdivision 3, and public data about applicants. As I mentioned, names of applicants are public when they are selected by the appointing authority for an interview. So if the applicants are not selected by the appointing authority to be interviewed, or they are interviewed by someone who is not the appointing authority, then their names remain private. Once they have been selected by the appointing authority to be interviewed, then their names are public. If the applicant is selected by the appointing authority but declines the interview, that applicant's name is still public. And there are 4 opinions cited here on finalists and names. As far as interview notes, applicants can get access to any data in those notes that are about themselves. Any data about the interviewer, if they are a government employee, are private personnel data on the interviewer. In that case, however, the interviewer would need to be the identifiable subject of those notes. If the notes are really just summaries of the applicant's responses to questions, then it is less likely that the interviewer is the subject of any of those notes. These considerations are discussed in Advisory Opinion 01-028. Opinion 05-035 talks about the type of test scores that would be public under Subdivision 3. The Commissioner concluded that objective or quantifiable scores from a test that is a requirement for the job are public data. For example, did the applicant do X number of sit-ups or run a mile in Y number of minutes? What was the score on the multiple choice test with objective answers? Those types of objective measurements are public data. The opinion also says that scores on subjective tests or assessments, like a Myers-Briggs personality assessment or similar type of evaluations, would be private data. Also, I'll just mention Advisory Opinion 13-002 again from the previous advisory opinion slide, saying that requesters are entitled to the redacted resume or application. I want to note here that just because something is listed in Subdivision 2 or 3 does not mean it is always accessible to the public in every context. Access to data can depend on how a data request is worded. Let's talk about employee names as an example. Employee names are public data under Section 13.43, Subdivision 2. If a government entity receives a request for the names of all employees in the entity needs to provide those names in a reasonable amount of time. But there are circumstances where a government entity might not be able to provide the names of employees. If there is a data request for the names of employees connected to another characteristic that is not public, the entity cannot provide access to the names. So let's say you receive a data request that states, I am requesting the names of all Department of Administration employees who live in Minneapolis. Home address or home city is not on the public list of elements. By releasing those names in connection with home city, the department would be releasing private personnel data. Another example would be, I would like access to the names of all city employees who have complained of sexual harassment. A public employee's identity as a complainant is private personnel data, and in that context, the city could not disclose those names. So, in making and responding to data requests, particularly for public data, you should be aware of how the context might affect access. Finally, we're going to finish up a little bit here with elected official data and classifications. The Data Practices Act classifies a limited amount of data related to elected officials. Section 13.601 clarifies that financial disclosure statements of elected or appointed officials are public data. It also classifies correspondence between elected officials and individuals as private data. However, there is no overarching classification of data about elected officials, and the Data Practices Act does not say whether elected officials are employees for purposes of Section 13.43. There are several advisory opinions stating that a government entity must make the determination about whether elected officials are employees, and this analysis was confirmed in an unpublished Court of Appeals opinion. If they are employees, then data about them are classified according to Section 13.43. If not, then the data are presumptively public, except for the correspondence classified by Section 13.601. If elected officials are going to be employees, entities should try to memorialize or document that in some way so that the public and the elected officials know what to expect regarding the data that entities maintain about those officials. Additionally, Here are some advisory opinions regarding the determination about elected officials and the classification of their correspondence for your reference. Okay, so that wraps up the government personnel data basics, and we can take some time to answer your questions. Remember, when sending your questions in, send them to all panelists so we can make sure that we see them. Remember, we'll be covering employee discipline data in a future session, so we'll likely save any of those questions and answers for that webinar in just a few weeks. A few reminders on this slide and that the slide deck is available on our website, and you can access the recording on our YouTube page in the next day or two. Going to put the evaluation in the polling panel. If you would please fill that out and let us know how we did and what other topics you'd like to see in the future, that would be much appreciated. We want to make sure that these webinars are useful to you, so thank you in advance for that feedback. And so from here, I'll go on mute. And as we're reviewing the questions, you may hear some silence. And so know that we are taking a look at your questions and working through them. But we'll start working through that Q&A now. And I'll also put the poll up in the panel here too, just in a moment. Thanks.
Thank you, Casey. I can kick it off with the first question. So one moment here while I note it so it appears. So the question is, if an entity does auto post to all county employees related to resignations and retirements prior to the employee's last day, would that be considered a violation? Great question. So let's break it down a little bit. So information regarding resignations and retirements, like why someone is ending their employment, is classified as private. And that's because it's not listed as one of the public data elements that Casey mentioned in 13.43 subdivision 2. This is disregarding discipline data, which we'll talk about in a later webinar. But information about, Ellen's retiring, that is technically private. Information prior to the last day, on the last day, the last day hasn't happened yet if an employee's last day is a few weeks out. So we don't know for sure that it's their last day. So I would say it's not one of those public data elements yet that will occur after the last day happens. So that anticipated last day is probably going to be considered private too under 13.43 subdivision 4. So you have sort of two private elements here, and there may be other information in this email that's getting sent out, right? So-and-so is retiring after so many years, they're going to go live on an island, whatever. All of that's really going to be private data on the employee. But the question is about sharing it to county employees, right? An email that's sent out prior to them leaving. And so you can share data that's not classified as public within your entity if there is a work assignment. So let's say that the supervisor determines everyone needs to know so-and-so is retiring to prepare, right, for the transition, to transfer some knowledge. They may think it's a work assignment to share some of that private information. So that is a possibility. You may also receive consent from the person, from the employee whose data it's about. Maybe they're like, yeah, I want everyone, to know where I'm headed and what's going on. I consent for you to release this data, to share it with my fellow employees. So that's another avenue to share it as well. If you don't have a work assignment and if you don't have consent from that employee, then it's really a risk assessment to you whether or not to share those private data to the other employees. So that would be a determination you would have to make. Hopefully that helps. Thanks.
This question is about some information that MMB publishes. I noticed that MMB published payroll data does not have my employee ID, but a temporary ID. Should that data be included? Should that data include all potential IDs? I don't know what requirements there might be for MMB to publish that information, but in response to a data request, you would provide the ID and any gross salary information. But in terms of what entities proactively put out, obviously it should be public, as Ellen just discussed. But I think MMB can decide which fields are appropriate unless they have a particular statutory responsibility to publish that data. The next question is a common one. It says, is leave coded as FMLA or future PFML public data? And I think generally how we think about FMLA is as Casey talked about, it kind of depends on the coding and how your entity does it, but that FMLA doesn't by itself necessarily tell the reason for sick leave. There's a lot of reasons under FMLA that might be covered. Some entities, however, have very specific codes around FMLA that might explain the reasons for taking the sick time related to either their own illness, the illness of a child, etc. So to the extent that those are very detailed codes, or the codes reveal the use of sick time, then I think that would be private. But just if you have just a general FMLA code, then I don't think that's necessarily private, but part of the public element under subdivision 2.
Okay, I do want to just hop in here and note that the evaluation, or kind of that poll to let us know how we did, is open, and so feel free to fill that out as we're answering some of the questions here. But another question we have here: for employees who fully or partially work remote from home, is their home address now public as their work location? Great question, and definitely one that we were getting a lot several years ago as everybody was working from home. But the short answer is I don't think so. I don't think their home address is necessarily their work location. It just simply says work location, not specific address or specific location in that sort of way. So I think the work location probably can be the primary office where somebody receives mail. And so if I'm working from home part of the time and then also working in the office part of the time, or even if I was working fully remote, I would expect that most of the mail sent to the data practices office would be sent to the administration building. And so I think, kind of that central location where that person can receive mail and, it be scanned in and sent to them, that's probably their work location, and it's not necessarily their home address. And so I think there is a little bit of flexibility there on that front.
Okay, for the next question, would gross salary include both annual salary and gross salary for a specific pay period or fiscal calendar year? Good question. So under 13.43 subdivision 2A, it states that gross salary is public data. So I think there is some room here to decide how you provide that gross salary data, whether you want to include it up to a specific pay period or if you're going to calculate it by the fiscal year. It doesn't explicitly say in 1343. So I think as long as you are providing some gross salary information, however you document or retain it, that would be appropriate and up to you how it's provided. So we had another question about sharing, and I'll just plug that our next personnel data webinar is going to be about sharing. So we'll discuss this in more detail, but the question we had is, can HR share within its entity with the person heading its alumni program that a staff person is retiring before their last day? If you have private data on an employee, and it sounds like you do here about someone retiring right before their last day, whether or not you can share it internally really depends on whether or not the responsible authority for your entity determines if there's a work assignment. So, it's going to depend on the work of that specific alumni program, whether or not you think that information is necessary for the other employees that would be receiving that. It's ultimately the responsible authority's call whether or not that work assignment is there. And of course, you can also always get consent from the individual as well. So those are two avenues to consider sharing those data. And again, just a plug for our webinar in a couple weeks, we'll talk about this in a little more detail. Thanks.
Okay, excuse me. The next question we have, a question on the retirements and resignations. So a lot about those this morning. What about positions that must have board approval for replacement? How does one request that the board fill a position that will soon be vacant? Um, Similar to the way Ellen was just describing it, typically if you've got some sort of board that your agency or your entity is working with, certainly they're connected to your entity. And they probably have a work assignment to receive data about who might be retiring or resigning in those situations. So I certainly think that you can share that information with board members so they can prepare, to know, hey, we're going to have to maybe do an approval process here or different things like that. This might come up in the open meeting law context also to some extent. Maybe there's an announcement that, someone is retiring after being with a group for a long time. Certainly that person can choose to disclose it themselves. I'm guessing this type of person would be an executive director or a pretty high level person who's probably attending those board meetings. But also the open meeting law does give some flexibility to discuss not public data during a meeting without liability if it's related to the body's business and agenda items. And so, that might be a situation where, hey, you've got to, formally announce that you're searching for candidates because someone is leaving your entity in the coming month or, a half a year away or whatever it is. So there's some flexibility there. Again, we'll talk more about sharing in a few weeks. But yeah, I think in this situation, probably those board members have work assignments to receive that information, to have that knowledge so they can prepare doing their duties to appoint someone new.
We have some comments and additional questions about this idea around retirement being private. And I think just to note, well, the comment was if someone agrees to have a retirement party, I think that is consent to share internally. And of course, that's an internal decision for you to decide if you have what you need to share that information. In general, if someone is retiring and you want to celebrate that, I would say that's up to you and probably a fairly low level issue. But if that person says they're going to retire and then they decide not to, that's something that could happen as well. Also, if somebody is requesting from your agency or entity, I want a list of your employees and who has retired and who has resigned and who has been fired, you're going to have to go through and really think about, well, at least for the fired one, we'll talk about discipline and complaints. But if somebody has resigned or retired, technically those data are private. And so in response to that request, you wouldn't necessarily give that out. But I think you certainly have the option to make some decisions around sharing it internally for, succession planning and for internal needs. And then, of course, for any celebrations you might want to have for that person.
And I do want to note that there is a CLE code for the webinar here, but after we wrap up, what I'll do is I'll go back to the first slide so folks can write that down if they'd like. Try not to announce it over the recording or things like that. So yeah, so certainly, I'll make sure to go back to that slide. So if folks want to write that down for the CLE credit at the end here, we can certainly do that. Okay, I'm not seeing any other questions coming in fast and furious here for the moment. And so, yeah, and we're getting close to time, so I think it's probably reasonable to wrap up here. So I just do want to remind you, thanks for attending and sending in your questions today. Stay tuned for Gov delivery notices for our upcoming workshops and webinars. We will be continuing our personnel data webinar series in just a few weeks, so you can go ahead and register for those webinars on the DPO website if you haven't done so already. Additionally, we're getting our half-day and full-day workshops scheduled once again. So if you're not already signed up for our newsletter, I encourage you to do so on our website so that you can receive information on new webinars and workshops as they are available. So thank you again for joining us and have a great day.